to reserve for rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of your time. The clock on the podium will reflect the total amount of time you have remaining, including what you may have decided to reserve. We record these proceedings, so when you approach the podium, we'd appreciate it if you would recite your name and the name of your client for us, please. We have read the briefs, we've studied the record in the case, and we've also discussed the case in a conference this morning. So with that, you may proceed.
Good morning, Your Honors. My name is James Backey, and I represent Ladine Steelman in her capacities as trustee of the Merman Living Trust and as personal representative of the Earl and Virginia Merman decedents' estates. Ms. Steelman is in the courtroom today. We thank you for this opportunity to address the court. This case is not about what is fair or unfair, or what occurred or what did not occur at the time of a loan closing. No, this case is about a promissory note acquired by U.S. Bank, and whether that note was, at the time the bank acquired it, a secured or unsecured note. And if not then secured, whether the Mermans thereafter acquired an interest in this property to which that lien, the deed of trust lien, could attach. At the center of the determination of whether the note was secured or unsecured, there is a statutory system anchored by ARS Section 33-412A, the so-called recording statute. That statute establishes a stable and reliable means for determining the rights of parties who claim an interest in real property. And it is for the benefit and sometimes for the detriment of all persons.
Mr. Bakke, let me
yes, Your Honor.
Let me ask you a question. I apologize for interrupting, but I want to, since you're on that topic of 33-412, you just mentioned subsection A. I want to ask you some questions about subsection B. Now, as I understand your argument, you believe that the deed of trust never attached because there was never a transfer of the subject property from the trust and the Mermans as trustees to the Mermans individually. And you believe that the quitclaim deed never accomplished that because it wasn't recorded. As far as I've gone, is that fair characterization of your argument?
It is a fair characterization.
I know you have more moving parts to it than just that.
Correct.
So just in that, on that particular set of issues. So when I look at subsection B, it states that as between the parties, you don't have to record it. And my question goes to this. It seems to me that the key transfer here for the deed of trust to attach is for the Mermans as trustees to transfer that trust property out of the trust by means of the quitclaim deed to themselves individually. And if that occurred, then they, of course, executed a valid deed of trust in their individual capacity. So why isn't this a 33-412 subsection B case? Because we're dealing with as between the parties, between the Mermans as trustees and individually. Was that a valid transfer because it wasn't recorded? Why isn't that dispositive?
Because this case is not between the Mermans individually and the Mermans as trustees of the trust. Part B of the statute only applies as between those parties.
But under Part B, at the time, wasn't that an effective transfer?
No, Your Honor. That's the point. Part A and Part B have to be read together. And when you read Part A, it in unmistakable terms voids the quitclaim deed because it wasn't recorded. As to persons in the bank's position, the bank is both a creditor and a purchaser of an interest in real property.
Let me ask you a question, Mr.
Yes,
Bucky.
yes, Your Honor.
Isn't the key whether or not, and I read your brief, I read your argument, whether the Mermans had the capacity or the capacities to grant the deed of trust? And I thought your argument was they never had that authority to make that grant because they never owned the property. It was never transferred out of the trust to them individually. That's how I understood your argument. And when I look at subsection B, as between the Mermans, it was an effectual transfer. They did transfer it out of the trust to themselves individually. And then if they owned it individually, at the time they granted the deed of trust, it would be effective. It would be they had the capacity to grant that deed of trust to the lender. Why wouldn't that be the case?
Because the focus is on the wrong period of time, Your Honor. The focus needs to be on when the bank acquired the deed of trust, because that's what Part A of the statute refers to. At the time of the purchase, they have a right to rely on the then recorded record. And that governs these instruments. That governs the outcome, Your Honor.
But the then recorded record was the deed of trust.
The then recorded record is indisputable, Your Honor. The Merman Trust owned the property from before the loan transaction to that point in time. The Mermans did not. The Mermans signed the deed of trust, and therefore the lien did not attach. At the time of
Wasn't that a fraud? If they
Oh,
gave
no,
a,
no, Your
excuse
Honor.
me. If they gave a deed of trust as individual owners of the property, having not conveyed it to themselves, wasn't that a fraud?
No, Your Honor. They committed no fraud here. There's no allegation by the bank that the Mermans did anything untoward. The allegation by the bank is that the quitclaim deed inadvertently didn't get recorded. And that may be true, but that is irrelevant to the determination today, because the focus is not when the loan transaction occurred, but by Part A of the statute, the recording statute, the focus moves up to when the bank purchased the quitclaim deed. Because what we're trying to determine, Your Honor, is what was the interest that the bank purchased. And Part A says you look at the record at that point in time to determine their interest. All other things not in the record are deemed void. So that quitclaim deed is deemed void because it was not then in the record. So that is determinative of this case, Your Honor, because we know the subsequent recording of an image of that quitclaim deed was ineffective. It was not a transfer from the trustees of the Merman Trust to the trust, to the Mermans.
I'm sorry, counsel. I guess what's confusing to me is it's the deed of trust that creates the beneficial interest for the lender, and then it's the legal title is held usually by escrow company or the title insurance company. But the deed of trust was recorded. The interest, the beneficial interest that the lender has that was subsequently assigned to U.S. Bank is in that deed of trust. They're not gaining an interest in the quitclaim deed. That's only as between the Mermans to transfer that property out of the trust so the Mermans own it individually, and then they can grant the deed of trust. The recorded interest is the deed of trust. The recorded interest is what is granted to the lender. So what interest does the bank or the lender have in the quitclaim deed in and of itself?
Well, first of all, Your Honor, U.S. Bank was not the lender. U.S. Bank is a purchaser for value without notice of the existence of the quitclaim deed.
But their
and
rights,
Part A of the statute says in that case,
counsel.
Yes, Your Honor.
But their rights to have a trustee sale, because one of the allegations is that it was a sham notice of trustee sale, derived from the deed of trust. And so I guess it's their assignment of that beneficial interest in the deed of trust that gives them the authority to have a trustee sale.
And at the time of the execution of the deed of trust, the Mermans did not own the real property. So they, in fact, assigned no beneficial interest in the property.
I think your argument, I mean, there's no allegation that the Mermans engaged in fraud. No one's saying that. except that's the natural inference, I think, of the current argument that their daughter is making to undo the deed of trust. Because they, by executing the deed of trust as individuals, they represented that they owned the property, which they knew that they did because they had conveyed it to themselves. And by asking the deed of trust to be undone because they lacked the power after they said they had the power, I mean, to me, that just makes, that puts the Meermans in the worst possible light.
Well, I respectfully disagree, Your Honor. There has been no allegation by the bank that the Meermans were engaged in a fraud, and they clearly weren't engaged in a fraud. They did exactly what they were asked to do. They signed the deed of trust and delivered it to escrow. How is that fraudulent, Your Honor?
It is you, I am saying.
Yes, and I point out, I don't.
Your current argument.
And I don't see, Your Honor, as I pointed out, I don't see how doing what you were asked to do is fraudulent.
And I'm not saying that it is either, just to be perfectly clear.
Thank you, Your Honor. So there was no fraud at the time of the execution of the deed of trust. How is it fraudulent now to be asking this court to comply with the law and enforce the statutory and enforce the statutes that we have in this state? The legislature made the determination of who wins and who loses in this case, and they did so when they adopted Part A of the statute. When you read Part B, you have to read it in conjunction with Part A. It has to be interpreted together. And if you look at the Roe v. Schultz case, that's exactly what the court did there. And it ended up with a harsh result. And I think, Your Honor, that that's what you're feeling, that you're feeling that this is going to end up as a harsh result. But the statute says that doesn't make any difference. That's irrelevant to the determination, because we look to what was the interest of record that the bank acquired. And when the bank acquired the deed of trust interest, the record is undisputed. The Meermans never owned an interest after from before they signed the deed of trust. They continuously owned the title to the property in their capacity as trustees.
Despite that they signed their quick claim deed over to themselves individually.
The quitclaim deed is not of record, so it's immaterial to this determination. The court and the bank can't rely on it because it would give the bank a benefit that they did not purchase. What they purchased was an unsecured promissory note.
But they thought they were buying something different.
I would disagree, Your Honor. I think this is a case of the mystery bag. When the bank purchased the assets of Downey Savings and Loan from the FDIC, there's probably tens of thousands of loans that they purchased. It's a mystery bag. They have no clue whether the interests in there have attached to the property or not. They probably didn't care, or maybe the economics prevented them from looking at the record, but they had the burden, if they wanted to rely on the record, to look at it. And the statute says that if you don't look at the record and there are instruments that are not in the record, you don't get to rely on them. And now they're coming back and saying, but we want to rely on that instrument that's not in the record. That's not what Part A allows them to do. So they got this grab bag, this mystery bag of assets, and they probably assumed that those loans were all covered by title insurance. And so they had no risk by not looking in the record. But the effect of Part A of the statute is, if you don't look in the record, then you get burned by, if you're going to then later on try to rely on unrecorded instruments that were not in the record at the time of your acquisition, you don't get to rely on those. That's what Part A says. And Part B does not relieve U.S. Bank of that voiding.
Wouldn't that argument be more effective if the deed of trust hadn't been recorded? I mean, it seems like I mean, I understand if the deed of trust had never been recorded and they were trying to enforce that grant, I could see that, but I'm just not, well, go ahead, counsel.
Again, Your Honor, we're not dealing with...
I think I understand your argument.
Okay, we're dealing with the quitclaim deed, and it didn't attach. So you look to the statute to see what was the interest the bank purchased. You have to look at what was of record at the time of the bank's purchase. Everything that happened before that is irrelevant. It's irrelevant. It's irrelevant what happened at the closing. I think that the escrow company actually intentionally did not record that quitclaim deed. I've made an argument in my briefs, and I don't want to go into those weeds because I don't think it's necessary, but there's plenty of argument in the briefs to establish a question of fact as to whether there was delivery, a requirement of ARS Section 33-401, whether there was delivery. We know under Arizona law that delivery to an escrow company is contingent upon the conditions in the escrow, and we know that there were conditions in the escrow that were not met that made that delivery conditional. I don't think we have to go there because, quite simply, we're not testing what the bank purchased by what happened 6 years earlier. We're testing it because the statute requires us to test it as of the date of their purchase.
Mr. Bakke, before you sit down, given that the bank is trying to or has set a trustee sale as part of an action to enforce a debt, would you agree that whichever side wins, it's entitled to attorney's fees under 12-340-101?
No, Your Honor. As I said in my brief, the counterclaim of the bank is you can't have a counterclaim to quiet title to property when you have no title interest.
No, I'm not talking about the claim for fees under the quiet title action.
Oh, I'm sorry, Your Honor.
I'm sorry, and I should have specified. I'm talking about.
I think you did specify a statute. I thought it was the
12-341-01.
Oh, 12-341, not
which is the action arising out of a contract. Since this can be thought of as to enforce a note, would you agree that whichever side wins is entitled to fees under that statute?
I don't know, Your Honor. I haven't really thought about it in that context, but I can tell you why they're not entitled to it. They did not request it in their original pleadings.
What about on appeal?
I don't believe you can cure the problem by putting it in a pleading for the first time on appeal.
No, I mean fees on appeal.
Oh, fees on appeal.
Under the 12-340-101.
I think that this matter does arise out of contract, Your Honor. I think the resolution is governed by 33-412A with respect to the substantive issues, and I suppose, again, I haven't really thought that through as whether or not they have an entitlement to attorney's fees for the time here on appeal. I can't imagine how they would be entitled to stay with the judgment that they have based on the statutes.
The fee statute would
right.
give it to you
I
if you
understand
prevail.
I can't imagine. The reason I didn't think about it, Your Honor, is because I can't imagine how, under the statutory scheme that we have, that this court will not reverse the lower court's judgment. That's how convinced, how certain I am that that's what is required of us when you look at the statutory scheme.
But then you would be entitled to fees under 12-340-101 on appeal?
We would be entitled to fees because if you reverse the lower court, you would enter judgment on our quiet title action, and we requested fees on that basis.
Right.
The bank
I know
also,
you have a very positivistic view of your chances on appeal, but what I'm asking you is a very narrow question.
Yes.
If you prevail, if you're the prevailing party on appeal, would you be entitled to fees under 12-340-101?
Yeah, if I asked for them, I think that that would be correct, Your Honor.
Okay.
And it looks like I have 56 seconds. So I'm going to stop.
Okay.
Thank you, Your Honor.
Your Honor, Mike Platty here, Dickinson Wright Law Firm, here on behalf of the Appellee U.S. Bank National Association. I'm a little old school, so I brought a board here just for illustrative purposes.
I feel like I'm back in the trial court. This exhibit. But.
I am very old school. I'll be very brief. I think it bears worth mentioning very briefly what's undisputed here. Undisputed that the Mermans received $610,000 back in 2006, enjoyed the benefit of that. It's undisputed that they pledged their Paradise Valley home as security. It's undisputed that they executed documents. All the documents we're talking about, it's not disputed that they were executed at all. Okay? And I think what the focus should be here, what the argument is, and I think Judge Gould expressed it well, there were two particular documents back in 2006, trust conveyed by quitclaim deed to the Mermans individually, and the Mermans executed deed of trust to Downey. Those are the two documents, right? Back in 2006, they want you to say, because it wasn't recorded, they want you to say, this never happened, therefore the deed of trust lien didn't attach. Statute 33412B says this did happen. Recording doesn't matter. Okay? It did happen. The Mermans did transfer from their trust to themselves individually, and then they did give this deed of trust to Downey. So in 2006, that deed of trust lien attaches to the property. And thereafter, to put it simply, go back to law school. When you acquire rights, you acquire the whole bundle of rights. Okay? When U.S. Bank acquired the deed of trust, they acquired it all. And they acquired a valid deed of trust on the property that attached in 2006. Okay? It's that simple here. Okay? So in the end, what my client is trying to do is get repaid the money that they loaned, $610,000. And to be frank here, we have not received a payment. This is all in the record. We've not received a payment since mid-2011. And we've been enjoined from this trustee sale for 2.5 years, since late 2013. And we're asking this court to put an end to that. Okay, affirm the trial court.
We understand. Let me ask you a question, counsel. I want to pick up with Judge Johnson's question at the end to Mr. Bakke. On appeal, fees on appeal, does this action arise from contract such that you can obtain fees under 12-340-101 if you prevail? Or could Mr. Bakke obtain it conversely?
Correct. The action arises under contract. There's a contract between, because my client's a successor to Downey, and the appellant here is the successor to the Mermans. There was a contract between them, and we claim them in our briefs under 12-340-101.
Can I explore that with you just a little bit?
You bet.
Okay, so we know that under the deed of trust, there's two rights that your client had. Setting aside, there's some statute of limitations issues and so forth, but setting that aside, you could have tried to execute on the note or have a trustee's sale. When you opt for the trustee's sale, you forego the right under the note and you pursue that secured interest, and so you foreclose on the property, non-judicial foreclosure. It would seem to me an argument could be made. I'm not promoting this argument, but an argument could be made that the claim when you are pursuing the notice of trustee sale and you're pursuing the foreclosure sale wouldn't arise from contract. It's just an action of property. You have what 12-1103B or whatever that statute is. So what do you say about that? What's your response to that?
My response is we did request under both.
I understand that.
But I am not aware of any authority.
I want the conceptual.
Yeah, I'm trying to give you the conceptual here. And I am not aware of any authority that says what you're saying. I am familiar with the statute 12-340-101, talks about matters arising out of contract. And I think deed of trust foreclosure arises out of a breach of the note. And therefore, that would be the connection. that the matter arises out of contract and it would be a proper matter for fees to be awarded. Again, I'm not aware of any authority that says precisely that. I wasn't focused on that today.
Do you have a case? What's your best case?
I'm sorry?
Is there, this is an issue that always is addressed in the last paragraph of
Right.
the decisions.
Right.
I'm just wondering if you have a case in mind that you can point us to.
I don't.
Okay.
I do not have
Okay.
that's what if there is a case out there, I picture that's what it says.
About a
conceptually.
chart. Do you have some chart somewhere?
I don't have a chart on that.
Backside
either.
of that one?
This is the only chart I brought with me today.
Okay.
What's your answer to the argument that U.S. Bank bought a mystery bag that you didn't know that you were buying a secured interest?
I think counsel is speculating about things that are not in the record, number one. Number two, I can give you the site. It's in the record. It's attached to tab 6 of the opening brief, Exhibit 8. That is the assignment from the FDIC to U.S. Bank, and it talks about all interest. We got all interest, and again, I'll go back to law school, that whole bundle of rights. We got everything, all of this deed of trust stuff that attached in 2006. That would be my answer. And if you have no other questions, I'll sit down and defer to my co-counsel.
What issues were you going to address versus what issues was your co-counsel going to address? So we'll know the parameters here.
Yeah, I mean, so on the parameters, I addressed in our brief how the deed of trust is valid. And we went through those arguments there. I believe my co-appellee counsel is going to talk about the issues that are pertinent, some of the claims against First American.
Recording, the false recording.
Yeah, right, the false recording.
The delivery as well?
If you would like, I could address the delivery argument. I mean, I feel the briefs are pretty self-explanatory, but we have a quit claim deed that was delivered to an escrow agent.
My question was just the division of labor, so I...
Yeah, no, that's all.
What about the right to, talk to us why, or explain to us why it is that your client, as Judge Gould says, holds a beneficial interest in the property through the deed of trust. Why does your client have a right under the quiet title statute?
It's a good question. To be frank, I believe the authority, and I believe Judge Gould authored a case a few years ago, the authority seems to point the other way, that a holder of a beneficial interest would not. It holds an interest in the property but doesn't have the proper standing to allege title. I don't think it's been definitive on that. I think you could try to distinguish Judge Gould's case, but I'm not going to try to do that. I believe that when the issue was raised in the trial court, it wasn't opposed on our motion for summary judgment, and that's how we proceeded.
Okay, thank you. Anything further of Mr. Platty? Okay, thank you.
Thank you.
Good morning. My name is Richard Cobb, and it's my privilege to represent First American Title Insurance Company. And I'm cast in the unusual position of making oral argument this morning after there's not been much said about my client. But I'll go ahead and reiterate some of the points in our brief and entertain any questions you may have. First, let me begin by saying that it's the position of First American Title that deed of trust and the quitclaim deed are enforceable, and that 412B is, in fact, the correct statute that we should all be looking at this morning as we consider this circumstance. I will raise briefly two issues that are unique to my client. As you know, my client prevailed below when the plaintiff sued my client for breach of contract. The plaintiff sued my client for breach of contract, and it became clear that my client was not the escrow officer in this matter. We were merely the underwriter. They then asserted claims against my client for breach of the memorandum of understanding. We pointed out that you can sue us in breach of contract if you like, but our name's not on it. They brought it up in response to our motion for summary judgment when the judge said that she was going to grant summary judgment in our favor on the point. The request was made, well, let us have time for discovery to see if maybe First American actually signed the memorandum of understanding. And the judge's point below was sound. There's two basic reasons why no additional discovery should have been granted. And the first was that even if my client signed the memorandum of understanding, that does not make the plaintiff an intended third-party beneficiary under the Sherman and Norton cases which we cited to you. They're just not named in the documents, and there's a sense that they may be incidental beneficiaries, as that term is used in both Norton and Sherman, but they're not the party to whom a promise was made, who could then come into this court and say we have the right to insist upon enforcement of this contract. And second, and just as important, originally, the plaintiff went out and sued herself and got a stipulated judgment saying that the deed of trust was unenforceable, and our court below said there was no issue preclusion effect to that because the bank wasn't invited, which makes perfect sense. Then, at the time when the bank was about to conduct the trustee sale, the plaintiff came into court at the preliminary hearing, the injunction hearing, and said, well, we think the deeds of trust and the documents were forged. The argument was made in court for the first time that they're forged. And the court held it over, and we went through discovery, and when we found the mobile notary, and the mobile notary was poised to testify, then they said, okay, we agree the quitclaim deed was in fact signed by Earl and Virginia. And so these arguments have all melted away now. And you're left with nothing but the fact that Earl and Virginia Merman signed the quitclaim deed. And as between Earl and Virginia Merman and the bank, it doesn't matter whether that document's recorded or not. It doesn't matter whether my client cuts the header and the footer off and puts the exemption language in when we record it. It's their signature.
Where did your client find the quitclaim deed?
The escrow agent, went out of business. Financial Title Company, I think was their name. And my client had a fax that contained the quitclaim deed on it. We went back through our documents. It's a paperless environment now, and so we had an electronic copy of it. And so we had it. We recorded it in 2012, and the argument was made, oh, well, you shouldn't have recorded the thing. It's a copy of a copy, and therefore it violates the memorandum of understanding. And the problem with the argument is that they have now admitted that there's no forgery, that there's no untoward circumstance here. The Mermans really did get $610,000 and pledged their house as collateral. They really did sign that document, and that really is their signature.
And made payments on the loan.
They made payments on the loan until Virginia died. When Earl was alive, they made payments. Until Virginia was alive, they made payments. And as soon as Virginia died, the payment stopped. And then the effort was made to simply keep the collateral without continuing to pay on the house. And so for these reasons, the breach of contract claim against my client is invalid. The claim that they should have somehow prevailed under the memorandum of understanding is invalid, and by the way, has been pointed out previous. There are requirements as to what you can and cannot record, but the rule is, under the statute, that once you record it, it's out there, it's notice. You can't say that you want to defend based on the fact that it shouldn't have been recorded in the first instance, which is all rather beside the point. And the point is that the Merman signed. So that's the first claim that the plaintiff brought against my client, was breach of contract. The next claim that they brought against my client was one that's actually a hot-button issue for my client and my client's industry. It's one that is talked about a lot, and it's important, and that is the wrongful lien statute. Now, we previously lost a case here on the Stouffer decision where we said we're not a party who purports to claim an interest in property because we're just foreclosing as trustee, and the court pointed out, well, nothing says you own it like saying you can foreclose it. And so we lost that one. But today we're here in a situation where all we do is we record the quitclaim deed from the trust to the Mermans individually. Our name is not on the document, and we don't purport in any capacity to claim an interest in the thing. We're not the escrow agent. We're not the trustee. We happen to have the thing, and we recorded it. And so for that reason alone, we suggest that 33-420 doesn't apply.
Versus being a trustee where you actually hold legal title.
Right.
For the beneficial
That's right.
interest.
And in this instance, that was not the case. We were not holding legal title. Now, there's two more tests that you have to meet to lose a wrongful lien case, and the judge below ruled in our favor, and we ask that you uphold that decision for the same reasons, which are, skipping to the end, there's no damage. In law, damage is not the loss of a windfall. Damage is loss of a right that you should have otherwise been entitled to. And what the plaintiffs seek is the right to keep the house and not repay the loan. That's a windfall. And what they have not provided to the court is any right that they have lost as a result of the fact that my client recorded the document. And then they make the argument that it is a forgery. Well, they asserted that and then backed off of that once the mobile notary was found. As the court below pointed out, forgery requires an intent to deceive. That's an element of forgery. And of course, there's none of that here. It really is their signature. It really is their document. There's no argument about that. The argument can be made, well, it contains a misstatement, it's groundless, and so forth. And you have the SWC baseline case, where a quitclaim deed was provided, and the court drew two distinctions and said, first, a quitclaim deed doesn't say you own it, it says you don't own it. It's somebody saying, I quitclaim my interest to another. It's not somebody saying, I own that property. And for that reason, quitclaim deeds, we respectfully submit, can rarely, if ever, be a minument of title, which is how I think the SWC baseline court phrased up the law. In addition to that, there's the fact that the quitclaim deed in this particular instance is something that is valid in the sense that they actually signed it. It's not like it's a false document. And the court said it has to be frivolous. And frivolous means there's no circumstance under which you could make a valid argument that it should be enforced. And what's interesting is in SWC they lost. You know, they threw that quitclaim deed out. But the court declined to impose 33-420 sanctions on the theory that the court said, and I quote, confusion reigned. Well, the court essentially said it was just kind of hard to pick the winner out of that horse race. It wasn't as if it was frivolous. And in this particular instance, the one thing we hope we have demonstrated is that we did win below.
I have a question for you, counsel. There was an injunction initially, and then based on the court's ruling, the court vacated or lifted that stay, and then the parties on appeal entered an agreement to put the stay back in place. So if you were to prevail in this case, is that self-effectuating? Does this court need to dissolve that stay, or is it by virtue of the language of that stipulation, once a ruling is entered, it's dissolved?
I would think it's the latter, and I would request the former. I think that all you have to do is uphold and it's dissolved, but we would request that you go ahead and actually say in the ruling just to avoid confusion and give greater clarity.
So was there a ruling that stayed? Was there a ruling adopting a stipulation by the parties to stay everything, or did the parties just voluntarily stay it?
You know, I'm not sure, Your Honor, on the distinction on that. It wasn't one of the issues raised, and I apologize.
And this may have been more Mr. Potty's issue.
If you'd like, I can address that.
Please.
Yeah.
Wait till you get the microphone.
In any event, I'll close, Your Honor, unless you have any further questions of me. My only thought is the 33-420 point after Stouffer really is a hot button point for our industry, and so we very much appreciate your taking time to consider that issue. Even though we won below, we hope that you'll rule in my client's favor for the same reasons, but give that great deference as you consider the opinion, because so many people are going to read that particular point. Thank you.
I believe we voluntarily entered into the stipulation so that plaintiff's appeal would be heard pending the ruling from this court. And if this court rules in our favor, I think it is self-perpetuating that, okay, now that our deed of trust is valid, the stay would be dissolved.
So your position is we don't need to specifically reference it?
But I would like you to.
Well, is there a stay? Is there a court-ordered stay currently in place?
We stipulated, and I believe the Court of Appeals issued a stay, and I believe the language saying pending the ruling on the appeal.
Yeah, you said the Court of Appeals issued a stay.
Correct. It was the trial court denied the stay,
okay,
and then the plaintiffs took it to the next level, which there was an appropriate procedural mechanism, and the Court of Appeals issued the stay pending the ruling.
So there is an order from this court?
There is an order from this court, but I think it would be wise if you rule in our favor to dissolve that stay.
Thank you. Mr. Bakke.
Thank you, Your Honor. Please don't take my passion for this position as impertinence to the court and have that affect your decision at all as against my client. And I may be beating a dead horse, Your Honor, but I did want to address the Part B Part A statute one last time. And Part B does not apply because the bank is not a party mentioned in Part B to be benefited by that statute. It very clearly says it's between the parties to the instrument being, in this case, the quitclaim deed, the Mermans and the Mermans Trust. The bank is neither of those parties. That Part B does not serve to revive an otherwise void instrument voided by Part A. Does that make sense? In other words, Part A voids unrecorded instruments. Part B does not revive it as to the parties named in Part A. That would make no sense for it to do so. And that's what they're asking you to do, is to revive a deed that by statute is deemed void.
Okay.
Because I have just one quick question. If you're successful, is your client unjustly enriched because she has a house and there's no mortgage to be paid on that?
I'm sorry, I got the part about...
I mean, she has a house. Is there any claim for unjust enrichment because she has a house and the mortgage goes away?
I'm still confused by the court's question. If the court rules in my client's favor on count one, you would be quieting her title as trustee in the property free of the claim of lien. Count two of the lawsuit says a request that a declaratory judgment be entered, finding that the statute of limitations has run on the note. So yes, she would receive the house free and clear.
Thank you.
If that was the question.
Yeah.
Thank you, Your Honor. Thank you.
Thank you to all the lawyers for your briefs and for your argument today. We'll take the matter under advisement and issue a decision in due course. Now we stand adjourned.
Carry this stuff on down.